If you're not a Kiwi, can you still invest in New Zealand property and businesses? Well, the answer is yes, you can, provided you are able to obtain consent from the Overseas Investment Office and can satisfy the conditions under the Overseas Investment Act of 2005. Let's take a look at consent. Before a foreign investor, be that a non-resident, a company, a partnership, a joint venture, trust or an associate of a foreign investor, is able to invest in New Zealand property, they may first need to apply to the Overseas Investment Office for consent to purchase the property, including sensitive land or a significant business asset worth more than $100 million. Such consent will often be granted if the purchase of the land by the foreign investor is in some way likely to benefit New Zealand, or the purchaser wishes to purchase the land with the intent of residing in New Zealand indefinitely. Deciding if consent is required is often a complicated procedure involving legislative interpretation and several government department searches. It is therefore recommended that legal assistance is obtained. So, what is sensitive land? Land will be considered sensitive if it is land described under Part 1, Schedule 1 of the Overseas Investment Act 2005. As a general indication, such lands are often defined by their size, position, classification, use, or historical and cultural significance. The Act provides a list of sensitive lands that may and may not be purchased. And what is a significant business asset? An investment in a significant business asset is an investment to purchase 25% or any percentage above 25% of a business, an investment in a business that exceeds $100 million, or if the business is carried out in New Zealand for more than 90 days per year. What about fees? The correct fees in relation to the property being purchased must be submitted with the application before the application will be processed. These fees and charges are listed on New Zealand's Land Information website.